namely Bhausaheb Ramesh Surushe seeks anticipatory bail in crime number 568 oblique 2021 registered against him in Taluka Jalna Police Station Jalna in respect of offense punishable under section 326, 324, 504, 506 read with 34 of the Indian Penal Code. Para. In short, the applicant submit that he is not involved in the alleged offense, but his name has been named in FIR without any reason. There is on delay in lodging FIR. The applicant is 20 years old and taking education in JES college. Nothing is to be seized from the applicant. He is permanent resident of Rohanwadi in Jalna district. He has reasonable apprehension of being arrested in false offense. Hence, the applicant urged that he be enlarged on pre-arrest bail. Para. The learned EPP prayed for rejection of the application on the ground that the applicant is named in FIR and specific role is attributed to them. The accusation against them is grave and serious, which require detailed interrogation. If the applicant is released on pre-arrest bail, he may flee away from justice and tamper with the evidence and intimidate the witnesses. Para. Heard the learned advocate Shri M. Tade for the applicant and learned AGP Shri D.N. Kole for state. Para. Having perused first information report and remand papers, it appears that the applicant is alleged to have assaulted de facto complainant with an axe and caused grievous injury. The specific role and overt act is attributed to the applicant. Para. The investigation officer has categorically stated that the weapon, that is X, used in the offense is yet to be seized. According to the investigating officer, custodial interrogation of the applicants is a must. Para. Having considered the content in the FIR and remand papers, I find that there is a sufficient material on record to show prima facie involvement of the applicant. Custodial interrogation of the applicant is a must to enable the investigating officer to recover weapon used in the offense and to elicit relevant information pertaining to the crime. Para. The power under section 438 of criminal procedure code is of an extraordinary character and must be exercised sparingly in exceptional cases only. Para, where a legitimate case for remand of the offender to the police custody under section 167 into bracket 2 of CRPC can be made out by the investigating agency or a reasonable claim to a seizure incriminating material from information likely to be received from the offender under section 27 of the Evidence Act can be made out. The power under section 438 not to be exercised. Para, the applicant has merely stated that the allegation leveled against him are groundless, but there is nothing on record to make out prima facie case for grant of prayer of pre-arrest bail. There is prima facie material against applicant to show his complicity in the crime. Consequently, the prayer for pre-arrest bail is turned down. The following order is passed. The application stand rejected.